Hello everyone. We welcome you all to our second series of Lawyers on Company Law, a byproduct of our YouTube channel, The Noble Litigators. Today, I'm Advocate Upasna, Legal Associate from the Law Offices of Kuvar Vivek Tanwar, Advocate and Associate, is going to discuss about the shares and its kinds. Share capital of a company is divided into units, and each unit is called share. The Companies Act defines the share as a share in the share capital of a company and includes stock. Share is the interest of a shareholder in a company measured by a sum of money. It secures to its owners the right to receive a proportionate part of the profit, if any, and the proportionate part of the assets of the company upon liquidation. On the other hand, the shareholder may also be required to pay the full value on winding up. Share is a movable property, transferable in manner provided by the articles of the company. Now, as per section 43 of the Companies Act, the company limited by shares may issue the following four kinds of shares. First is preference shares, second is equity shares, and third is equity shares with differential rights, and fourth is sweat equity shares. So first of all, preference shares. Preference shares are those shares which carry the following preferential rights over the other classes of shares. First, a preferential right in respect of a fixed dividend, and second is a preferential right as to repayment of capital in case of winding up of the company. Preferential shares are of different types. First is cumulative and non-cumulative preferential shares. A cumulative preferential shares has a right to claim the fixed dividend of the current year out of the future profit. If a company is unable to earn sufficient profit in any year, the deficiency is made good out of the profit of the subsequent year. The holders of non-cumulative preferential shares paid only out of the profit of that very year only, and is not allowed to accumulate to be paid out of the profit of the future years. Now the second is participating and non-participating preference shares. Beside a fixed rate of dividend, the holders of the participating preference shares entitled to participate with the equity shareholder in the surplus profit. And the holders of the non-participating preference shares are entitled only to a fixed rate of dividend, do not share in the surplus profit. Now the third is convertible preference shares and non-convertible preference shares. The holders of the shares of the convertible preference shares have a right to get converted their preference shares into equity shares within a certain period, and the holders of the non-convertible preference shares do not carry the right of the conversion into equity shares. Now the seventh is redeemable preference shares and irredeemable preference shares. Shares which can be redeemed after a fixed period or after giving a certain notice at any time at the will of the company out of the profit of the company is called redeemable preference shares. And irredeemable preference shares are of the permanent and perpetual in nature, which cannot be redeemed during the lifetime of the company. The Companies Act does not permit a company to issue any preference shares which are irredeemable or redeemable after 20 years from the date of the issue. Now comes to the equity shares. Equity shares are those shares which are not preference shares. They do not carry any preferential rights. They have the right to participate in the decision making of the company and are entitled to voting rights. They receive dividends out of the profit as declared in the annual general meeting only after preference shares have been paid their fixed dividends. Now the third is equity shares with differential rights. A company limited by share may issue shares with differential rights as to dividend, voting or otherwise, but subject to the following rules. First, the articles of association of a company authorize the issue of these shares and only to the extent of 25% of the total issued share capital. Second is, approval of the shareholder is obtained by passing of ordinary resolution at a general meeting. A listed company is required to pass the resolution through postal ballot. The company has distributable profit in the terms of section 205 of the Act and has not defaulted for the 3 financial year preceding the year in which it was decided to issue such shares. And the company has not been convicted of an offence under SEBI Act, Securities Contract Regulation Act or the FEMA Act. Now the fourth is sweat equity shares. Sweat equity shares means equity shares issued by a company to its employee or directors at a discount and for a consideration other than cash. According to Section 54, a company may issue sweat equity shares of a class of shares already issued if the following conditions are fulfilled. The issue is authorized by a special resolution passed by the company. Second, the resolution specifies the number of shares, the current market price, consideration if any, and the class or classes of directors or employees to whom such equity shares are to be issued. Third, 1 year should have elapsed at the date of such issue, since the date on which the company has commenced business. Where the equity shares of a company are listed on a recognized stock exchange, the sweat equity shares should be issued in accordance with the regulation made by SEBI, and if they are not listed, in accordance with such rules as may be prescribed. The rights, limitation, restrictions, and provisions applicable to equity share shall be applicable to sweat equity shares. That's all about shares and its kinds. I hope you all have liked our podcast channel. If so, then do please subscribe our channel, The Noble Litigators. You can ask questions, give feedback, and for further queries, contact us on our website www.advocatetanwar.com. Thank you and have a good day.